Guest on Keel heard via the Jack Spring Electric Keel Newsmaker hotline. Political writer and analyst and smart guy Royal Alexander is here. Welcome back, my friend. How you been?
Great, Robert. Good to be with you.
Just when you think 2020 can't get any more strange or weird, it's the death of Supreme Court Justice Ruth Bader Ginsberg. Where do we begin with that? Does President Trump, if you listen to the Democrats, he dare not submit a name to the Senate for as a nominee for hearings because that's just not done? Well, that's not exactly the case, is it?
No, Robert, it's all the Constitution says is that the president shall nominate and the Senate, with giving its advice and consent, the president shall appoint a judge or justice of the Supreme Court. It doesn't say anything else. In other words, all of what you're talking about, all of this idea of a no election year, yes, an election year for the appointment is just politics. But all the Constitution requires is that there be a vacancy and the president nominate and then the Senate can advise and consent and either confirm or reject the nominee. But this idea that there's some sort of a prohibition, it's just not true.
If you look at averages, it averages about a month and a half to 70 days, something like that. What is that? 2 months plus to get a Supreme Court nominee through. Doing it in 45 days before the election would be super fast, Royal, in terms of looking at the history.
But you've got till Inauguration Day. You've got till January.
Sure.
Yeah, that's all true. Robert's right. You have clear up till about January the 20th. But, Aaron, to answer your question, I think it is a brisk pace, but just keep in mind, for example, if it's Amy Coney Barrett, she has even been vetted recently when she got on the appeals court. So this is the point. As a conservative, I hope he moves ahead. I mean, when people say, well, what authority does he have to do it? Well, he was elected in 2016. In other words, he's the president, they're the Senate, and when there's a vacancy, and even besides the politics of it, think about this. It's just hard for the court to function with 8. I mean, we saw that with Justice Scalia. We saw those 4-4 ties, and the law remained unresolved. And if there's a lot of disputes coming up from the presidential election, like there very likely could be, it just is going to be a real problem if there's not an uneven number to break a tie.
So the question is, does the president, if he nominates, and it looks like it's going to be Judge Barrett, the first question is, does the president have the numbers when you look at Maine Republican Senator Susan Collins saying, I just don't think he should do this. The female senators, it's Murkowski from Alaska and Collins from Maine. Despite their traditional reticence to go along with this president, if he were, President Trump, to nominate Judge Barrett, would they ever dare vote against another Republican woman or conservative woman?
That's such a great question. This is what I think happened. And remember, President Obama encouraged her to retire, Justice Ginsburg, when he was president so he could replace her with someone of his liking, of perhaps her judicial philosophy. I think it's quite likely it would have been a liberal. But I think she was thinking, well, I'm going to hold on because I'm sure Hillary Clinton is going to be elected and she can. And maybe she was thinking, look, I'm a female justice. I was a groundbreaker. If Hillary Clinton wins as the first female president, it just all ties together nicely, except she, made a mistake. Hillary was not elected. So then she was forced to try to stay alive at least through the term. And it honestly doesn't matter that she wanted to have a new president appoint her replacement. Justices don't get to decide how that's done. So what will Murkowski do? What will Susan Collins do? And there still could be a third one that the president could lose and be at 50 and then have Mike Pence break the tie at 50-50. Mm-hmm. But again, it's just a question of, let's be honest, the Democrats, if the roles were reversed, I promise you they would push ahead and try to do this.
But wait a minute now. Let's be fair. When Justice Antonin Scalia died 4 years ago, it was Mitch McConnell saying, no, let's wait. Let's not push this through. That's this gridlock, flippity-floppity stuff that Americans are sick of. You wanted it that way 4 years ago, Mitch. Now you want it different now. That's where I am, Royal. I'm like, what's different now? Can you help me with that?
Aaron, that's a great point. To me, it's just politics. And let me just say this. Both sides have been on both sides. Both Republicans and Democrats have been on both sides of this issue. And politics just means when they have the advantage, then they're going to be in favor of doing it. When the other party has the advantage, oh, no, it's a terrible idea. But all I'm saying is the constitutional authority to do it is there whenever there's a vacancy. The time, it's an election year, not an election year. None of that affects when there's a vacancy on the Supreme Court. And whoever is control of the Senate, so then you just say, well, it is about raw political power. Unfortunately, the country is so polarized right now, Aaron, it really is about raw political power, because I'm certain if Schumer, but that's what I mean. They've both been on both sides. When it benefited them, they've been in favor of moving ahead. When it doesn't benefit them, they've been in favor of stalling. And both sides do it.
A threat that a number of Democrats floated this past weekend. If the president sends a name to the Senate and it somehow passes, then when we take control of the Senate, we're going to pack the court, meaning if they had control of the legislature, they would increase the number of justices on the court by as many as 6 more, up to 15. They're going to do that anyway. I mean, that to me is, look, if you take control of this, you're going to pack the court anyway. So to me, that is an idle threat. Your thoughts?
I agree, Robert. Look, we had FDR, President Franklin Delano Roosevelt, threatened his court packing plan back in the late 30s and in the 40s when he wasn't getting his economic measures that he wanted passed. In other words, he was turning into law, and the Supreme Court was saying, under the Commerce Clause, you don't have the authority to do everything you're doing, President Roosevelt. He got mad and said, well, if that's the case, I'm just going to pack the court. But we have something called the judiciary. Article 3 gives Congress broad discretion to say that what it says is there's going to be one Supreme Court and such inferior courts as Congress may ordain and establish. That's Article 3.